Hello students, I am going to give a legal dictation at the speed of 110 words per minute for the purpose of all High Court's skill examination. So, be ready. Start. Heard learned counsel for the petitioner and Sri M.D. Misra for the landlady respondent. The present petition has been filed seeking quashing of the orders dated 12/5/2016 and 9/3/2017 passed by prescribed authority Judge Small Causes Jhansi in case number 26 of 2014 and additional district judge Special Judge Jhansi in rent control appeal number 9 of 2016 respectively. A perusal of the record would reveal that the landlady respondent had filed application under section 21(1)(a) of UP Act number 13 of 1972 against the tenant petitioner for release of the accommodation in dispute by claiming that she had been residing with her father-in-law, mother-in-law, Jethani and children, and the accommodation available with her was not sufficient to meet the need of her family, which included her husband and children, and therefore the accommodation in dispute was purchased by her white sale deed dated 27/1/2011 to fulfill her family's residential requirement. The release application was filed on 22/4/2014, that is, after expiry of 3 years from the date of purchase, by alleging that a notice was given to the tenant petitioner disclosing that the accommodation in dispute was purchased by her, which she bona fide required for her personal use, and therefore he may vacate the premises. The release application was allowed by the trial court, and the appeal preferred by the tenant petitioner against the order of release was dismissed. Both the courts below have found that the need of the landlady respondent was bona fide because she was residing with her in-laws where the accommodation was not sufficient, and therefore the accommodation in dispute was bona fide required by her. On the question of comparative hardship, also, both the courts recorded finding in favor of the landlady. Learned counsel for the petitioner has assailed the impugned orders on the ground that the notice as contemplated by the proviso to subsection 1 of section 21 of UP Act number 13 of 1972 was not given, and therefore the release application was not maintainable. A feeble attempt was made to disclose that there was no bona fide need because the landlady had sufficient accommodation at her father-in-law's house. Inviting attention of the court to Annexure 3 of the petition, which is copy of the notice dated 22/11/2011, learned counsel for the petitioner submitted that a bare perusal of the notice would go to show that it was given for bringing a suit for arrears of rent and eviction. Moreover, the notice does not give 6 months period to vacate, and it only seeks to terminate the tenancy by providing 1 month's time to vacate. Therefore, it does not comply with the requirement of the proviso to subsection 1 of section 21 of UP Act number 13 of 1972, which is mandatory. Sri M.D. Misra, learned counsel for the respondent landlady, submitted that the notice as contemplated by the proviso was duly given, and both the courts below have examined that aspect of the matter and have found that there was a valid notice, and as such the release application was maintainable. It was submitted by him that both the courts below have returned concurrent findings of fact on the question of bona fide need and comparative hardship, which is based on appreciation of evidence on record, and therefore the orders passed by the courts below call for no interference. In respect of validity of the notice with reference to the provisions of the proviso to subsection 1 of section 21 of the Act, Sri M.D. Misra submitted that in paragraph 2 of the notice, the landlady had clearly disclosed that the premises in question was required for her own bona fide need, and for that purpose she would bring a proceeding in due course of time. It has been submitted that the proviso to subsection 1 of section 21 of UP Act number 13 of 1972 does not provide for giving 6 months notice. What it requires is that the landlady should give a notice to the tenant not less than 6 months before filing of application, meaning thereby that if notice has been given 6 months before filing an application under section 21 1A of the Act, and the application is filed after 3 years from the date of purchase of the premises, there is sufficient compliance of the provisions of the proviso to subsection 1 of section 21 of the Act. It has been submitted that in that instant case, the landlady had given notice more than 6 months before filing of application under section 21 1A of UP Act number 13 of 1972, and in said notice she had clearly disclosed that the premises in question was bona fide required by her, for which she would bring proceeding in due course of time. As such, there is substantial compliance of the provisions of the proviso to section 21 1A of UP Act number 13 of 1972. It was submitted that since admittedly the release application was filed after 3 years from the date of purchase of the accommodation, the release application was not hit by the said proviso stop. Please do share and subscribe for this channel.